I don't know how much we'll get to, but we'll get to as much as we can. All right. Tony, did you get the announcements, or do I need to do that again?
I know everybody on this case. That's fine.
Okay. Yeah, not surprising. All right, let's go ahead and proceed then.
Your Honor, may I share screen?
Yeah, give me 1 second. Go ahead.
Thank you. I will try to be as quick as I can, Your Honor. Thank you for allowing us to be heard with short notice. This has been an ongoing saga, and unfortunately, it keeps going from bad to worse. Can you see my screen okay?
I can.
Okay.
I can. And I've read the briefing on this audit report issue. What is the response from the defendants on this?
If I may just briefly, Your Honor, the issues have changed a little bit since this was filed over the weekend.
Okay.
If I can briefly just explain what the current status is.
Okay.
As you know, the audit was finally produced to us 8 months after it had been completed. It is a critical document because it ties Southfield directly to the behavior that they are trying to distance themselves from. We brought a motion to compel because this was highly responsive. No one had produced it to us, like I said, for 7 months, or the ancillary documents that went along with it and all the communications between the parties regarding this audit. Here on the screen now is the order that you signed telling the FSG defendants that they needed to produce all of the documents relating to the audit report, and same thing for Southfield to produce all of the documents relating to the audit report. Those were due by July 1 so that we could take depositions of Southfield, and then we're supposed to take depositions today of 5-Star Global's representative and then the auditor tomorrow. However, your order was just blatantly ignored, and both parties, both Southfield and the 5-Star Global defendants, are continuing to fail to comply and produce documents. And the issue now has become so blazing, I guess I would say, because what we have is 3 parties who should have the same documents. But every time we get something more from the auditors, it just becomes that much more clear that the other parties are continuing to hide highly responsive documents that tie them exactly to what we're trying to prove in this case. So, Your Honor, so the audit obviously was a critical document. I asked Southfield over and over and over to produce the audit in their records because we knew they had to have it. And over they denied even having a copy of the audit until their witness testified, I guess it was last week, testified that he did have a copy of the audit. So I didn't have confirmation from Southfield's documents until after deposing the representative that they had a copy of the audit. And this is important. So after the deposition, Ms. Eash sends me a letter and says that in April of this year, highlighted in yellow, this was the first and only time Southfield received this document. So she's representing to me after the depo that this was the first time they've ever had the audit. Your Honor, then yesterday, as all of this stuff has continued to unfold, I get an email from Mr. Harper, who also represents Southfield, responding to all of my requests saying, I know you're still hiding stuff, and yellow highlighting, he says to me yesterday morning, no, we have produced all communications with third parties that are related to the Mazars audit issue 2021. Okay, so then fast forward to last night at 6:51 p.m. and the Southfield parties make a document production, which I will address separately, but 5-Star Global makes a document production last night, so not Southfield. So they make a late night production prior to the time I'm supposed to depose their witness this morning. And their production just flies in the face of everything that Southfield has been representing. You're gonna remember, Ms. East told us that 3 months ago was the first time Southfield had ever had the audit report. However, the documents that Mr. O'Reilly produced last night show that David Lay is from Caledon. Eric is the one that is represented by Winston and Strawn, saying, hi, Eric, thanks again for the support letter. We wanted to check back with you to see if you've completed your review of the draft audit. And this is in 2021. So Ms. Isha's clients have actually had a draft of the audit since 2021 that has never been disclosed to us until last night. that they've had in their possession. And not only that, but this flies in the face of Mr. Harper's email, where he said that they had produced all communications regarding the audit that they had with any third parties. Clearly, that's not the case, because this is a highly relevant document that is responsive to both of those items. On Friday, well, the auditors, as you know, Your Honor, also signed an order that we could depose the auditors and get their documents. 5-Star Global instructed the auditors not to release the documents to us. So that created a huge issue last week, where we were filing emergency motions because 5-Star Global told the auditors, despite what Judge Hoffman's order says, don't produce any documents to the plaintiffs. So after I filed my motion, then 5-Star Global said, just kidding, never mind, we'll let the auditors release their documents after all, even though the judge had ordered it from the beginning. So we get the auditor's production on Friday, which we start going through over the weekend. My client worked through the night, all weekend, both nights, going through these documents, trying to piece this together. And what do you know? Winston and Strawn themselves, Your Honor, was having email communications directly with the auditor that was never produced to us. All of these months, here we are, less than a month from trial. This case has been going on since 2019. And the lawyers themselves are talking with the auditors about this exact letter that we've been fighting about, and that was never produced to us. There's multiple emails now. Here's another one that the auditors produced. No one else gave it to us. The auditors now, here's another one where counsel for Southfield is talking to the auditors exactly about this audit that we're fighting about, saying, hey, maybe we're not going to do the audit at all. There's no way these lawyers didn't know these emails existed. They're talking directly to the auditors, and this has been hidden from us this entire time. Your Honor, the Sloan letter is one that, if I know you read the briefing, so this one has been a massive issue, because this is a key document that will be front and center at trial. This entire time, we knew that this document had to somehow make its way from Southfield to 5-Star Global. I have asked so many times in so many ways, how did this letter get from Southfield to 5-Star Global? We want the transmittal email. Here's the responses that I got finally from Mr. Harper yesterday morning. He says to me, while we produced the Sloan letter, we have not produced and are withholding as privileged the email to FSG and counsel, which discussed litigation issues and happened to have the Sloan letter as an attachment. So this is important. Mr. Harper tells me yesterday morning that the transmittal letter of the Sloan, or the transmittal of the Sloan letter, wasn't produced because it was privileged, because it quote, discussed litigation issues. Okay. Then last night, when 5-Star Global makes their document production, they actually produced for the first time ever the transmittal email. When you look at it, there are no litigation issues discussed here, Your Honor, nothing. It says attaches the letter. We're still reviewing it. However, we wanted to get this in your hands now. Please do not release the support letter to the auditors until we get back to you that we have completed our review. So this is a hugely significant email, because Southfield is saying, do not produce this to the auditors. Yet Southfield represents to me yesterday morning that they didn't produce it because it's privileged. It discussed litigation issues. Your Honor, that can't be further from the truth. I now have it in my hands. There is no litigation discussed. This has been, I can't tell you the subject of how many emails and now 3 motions to get this that is clearly not privileged. So as I sit here this morning, I now know that there's a draft audit, which no one has given me still. There's communication between Southfield and its counsel and the auditor, which still has not been produced from Southfield. And there's communications with third parties that still has not been produced. All of this was the subject of the order that you already signed a month ago that should have been produced prior to the deposition of Southfield, and certainly was responsive from the beginning. And as I mentioned, with respect to Southfield, it's like the more that we get from other parties, the more that we realize that, and I'm try to be very careful with my words and not overstate, but the misstatements at this, like the level of misstatements at this point is just very shocking and upsetting that our clients are having to get pulled through this and go to this effort. With respect to 5-Star Global, as I mentioned, we're supposed to depose them this morning, which we intend to move forward with. It's been pulling teeth with them to get responsive documents as well. As I mentioned, they made a production last night, stuff that has been responsive for years now, Your Honor, relating to this audit. But there's still documents now that we've seen from the auditors that came in on Friday that 5-Star Global hasn't produced. I've got 3 right here. These are just 3 emails that are, I'm sorry, this is Mr. Irabali's email to me saying we've produced all responsive documents we have between FSG and Mazars, as well as responsive emails between Mr. Hughes and Southfield. So that's his representation to me on July 8th. But then once we get the emails from the auditors, it's clear that none of this is true. Here's communications from Mazars directly to Mr. Hughes, who I'm supposed to depose this morning. Here's another one, again, communications directly from these parties that are the exact opposite of what was represented to me by counsel as far as what had been produced. Here's another one. I mean, it just goes on and on and on. And we don't know what we don't know. So while there's some that I can say, okay, well, I know that they didn't give us that document. As I mentioned, there's just more and more being uncovered constantly. What we know we don't have from 5-Star Global, of course, is the draft audit, which we still don't have from anyone. Communications between them and the auditor, communications between them and third parties. So those are the current issues as of this morning that we know about. With your honor's permission, I would like to submit, I don't think I've ever done it in this case. I would like to submit briefing, your honor, for my client's request about the costs that we have spent on just this issue, trying to get the audit issues resolved and the productions done. So we intend to submit briefing on that with your honor's permission, because it has been tens of thousands of dollars for things that should have been produced on their own long ago. So that is the current status, your honor, of where we are and what we're seeking.
Response?
Your Honor, on behalf of Southfield, I'm going to be speaking today. Your Honor, all of this could have been resolved if plaintiff had just asked for a privilege log early in this dispute. Plaintiff didn't ask for the log because they don't want to have to log the stuff that they're withholding in this case. And I get that. The first time we ever heard anything about a privilege log, that Southfield heard anything about a privilege log, was when this motion was filed last Friday or Thursday. And that's the first time Ms. Pettit ever asked us to let her know what we were withholding as privileged related to this audit. If she would just review our privilege log, she would know that all of these alleged intentional, hidings, they're not intentional hidings. They are documents that Southfield alleges is privileged and can put on a privilege log for her to challenge. That is it. We have produced the emails that are responsive and not privileged.
How could the draft audit be privileged? I don't understand how that could be privileged.
So early on in the conversations, she didn't produce the entire email chain there. Early on in the conversations, FSG sent us a draft audit. We were reviewing those in anticipation of how they would affect this litigation. And we told FSG that we were doing so. And so that is privileged communication. This litigation was ongoing. When they told us they were going to be doing that audit, they sent it to us to review. And we did so in anticipation of litigation.
Do you represent the auditor?
No, these were not communications with the auditor. We have not withheld any communications with the auditor.
I just showed them on the screen. I mean, I'm sorry, I'll try not to interject, but I just showed them on the screen.
You showed one, sorry. We are not withholding communications with the auditor related to this draft audit. We received the draft audit from our co-defendants who we're working with under a joint defense agreement here. I believe the only communication that
I'm confused. Has the draft audit actually been produced or not been produced?
I've never seen it. And your honor, significantly, I may have left this part out.
Let Ms. East go.
The draft audit that was sent to us by FSG has not yet been produced because we believe it is privileged, and she would have seen that on the privilege log if she had asked for it before last Friday.
Your honor, may I respond just briefly to that issue? They never served a withholding statement. Under the rules, if there's no withholding statement, I don't have to go produce a privilege log because I didn't know until yesterday that they were asserting that these were privileged. We've now seen multiple of them. They are not privileged. And there was no withholding statement. So I cited it in our motion. I guess it's 193.3. Remember.
Your Honor, nobody in this case has served a privilege log, and there's a good reason for that. Nobody wants to undertake the time and expense. Well, actually, it's not as big of a deal on Southfield's part, but I'm guessing the FSG defendants and plaintiffs don't want to undertake the time and expense to log the hundreds of thousands of documents that they are claiming are privileged. If Ms. Pettit had asked for a limited privilege log tied to these audit materials, we would have given her one. She finally did ask last Friday, and we told her last Friday that we were willing to produce one. So I'm really not sure that there is a dispute left here. We will produce that privilege log. If Ms. Pettit does not agree with the assertions of privilege that we make on that log, then we can take that up with the court. We are also willing to produce our witness, Southfield's witness, for a limited additional deposition, given the 2 documents that we found responsive to the Mazars audit issue after his deposition. And I want to be very clear, after his deposition, we went back and on our own did some further searching. The problem was the documents that we uncovered that needed to be produced are literally communications that have happened within the past like weeks. So our document gathering for this case stopped as of last February, as of February, because that's when we were set for trial. When we realized that there might be some more recent communications, we expanded our search. We identified this handful of additional documents, and we produced them to plaintiffs on our own. We weren't trying to hide them. We didn't wait for plaintiffs to come ask for them. We produced them to plaintiffs on our own. And we are willing to put our witness up again on those limited documents that we produced after his deposition. And we'll get plaintiffs that privilege log. So I don't know that there's much of anything left in dispute here.
Your Honor, 193.3A says they had to have served a withholding statement. That was never done. We've checked all of their responses. There was no withholding statement. And now, like I said, there are multiple documents that we've seen that in no way are privileged. So even if they were trying to blame this on me for not requesting a privilege log, we've seen them now. They're not. And by the way, you can't just review something to see if that might help you in litigation and withhold it on that basis. The draft audit, I mean, my client has contractual rights. He's a 42% owner of the company. He literally has contractual rights to review all of the documents. They can't just simply review financial documents, withhold them from my client, and say it's privileged because they were reviewing it in the context of litigation. That audit is not privileged.
I'm still not clear how this draft audit could be. Okay, 2 issues there, I guess, is who had the duty? Did Ms. Pettit have the duty to request a privilege log, or did you have a responsibility to provide a withholding statement first? I mean, I do think 193.3A does kind of put the onus on you, Ms. Eash, to provide a withholding statement, unless there's some case law that I'm not familiar with that somehow modifies that rule.
Your Honor, I would agree with you that 193A does require us to provide a withholding statement. However, I would say then that everybody in this litigation is in violation of 193A. And Ms. Pettit and her clients therefore need to go back and log the hundreds of thousands of emails that they have told my client they are not allowed to look at because they're allegedly privileged. So what's good for the goose is good for the gander. Nobody in this litigation has served privilege logs, and everybody would need to do so if that's the standard we're going to be.
Your Honor, if I may, the issue is this, and first of all, I do believe that we've served a withholding statement. I'll double check on that, but I'm pretty sure that we have. In any event, the emails from Mr. Harper and from Ms. Eash don't make any sort of distinction. I put them on the screen. I mean, Mr. Harper says to me, we have produced all communications with third parties that are related to the audit Mazars issued in 2021. And then I get productions from 2 other parties that show that's completely false.
Your Honor, I disagree with that. We have produced our communications with Mazars. I think the only thing that Ms. Pettit can point to is a communication from Scott Ahmad sending a auditor's letter to Mazars. And yes, we produced that auditor's letter to Mazars. We didn't produce the underlying communications because we believe those are privileged. However, there are no other communications with Mazars that we are withholding in this case. If we could just serve the privilege log, plaintiffs will get what they need to challenge any type of privilege here. And we totally disagree. We disagree that the work product privilege and allied litigant privilege do not cover the documents that we are withholding as privileged.
Your Honor, may I jump in just because I think it ties into what Ms. Ish is arguing here.
Sure.
This notion that this is an emergency and that everything is being sprung on plaintiffs, in all candor, we take issue with. And if I can just show the court an example of why that is, the court is looking at an email from July 15th. So this is 8 days after the email that Ms. Pettit showed you, where I said that I believed that we'd produced everything. Ms. Pettit comes back at 5:37, Friday, July 15th, and says, we don't think it's possible all responsive documents have been produced. Now, as Ms. Ish noted, we were set for trial in February. Ms. Pettit specifically requested that the court lock the 5-Star Global defendants into their exhibits, specifically requested. So much like Ms. Ish indicated, we were not actively reviewing documents, we were set for trial. My response to Ms. Pettit came within 20 minutes, Your Honor, saying, I'll look into it if you think there are gaps. If you have issues, because clearly Ms. Pettit had something in mind, let me know. Let's meet and confer. I even offered to meet on Monday. This is Friday. Never heard a word back. Now we have emergency motions flying left and right on the eve of depositions. I would argue the emergency is in some sense of plaintiff's own creation, because instead of an ongoing dialogue, here's what I think we're missing. Here's the problem, where either Southfield or 5-Star Global or even Ms. Pettit can chime in on what the issues are. It's just constant motion practice that then wastes Your Honor's time on Monday morning. So what documents are out there we're trying to produce? This is we, the 5-Star Global defendants. Frankly, it seems like the goalposts keep shifting a little bit. We want the 2019 audit. Now in her motion against 5-Star Global, she adds a section about a current audit. Candidly, that to me is the equivalent of saying produce all documents related to a summary judgment brief your firm is in the process of drafting. It is ongoing. How am I supposed to do that?
But what about this draft audit? I mean, that's the thing that kind of concerns me the most about all this is there's a draft audit out there that was communicated. I don't know how you guys have a privilege and maybe there's some audit privilege I've never heard of, but how do you guys have a privilege when it comes to the draft audit? I just don't understand. None of you guys represent the auditors. So what privilege could there possibly be about the draft audit?
Your Honor, I'm sorry, Jim, we're jumping in on this. The problem I'm dealing with, Judge, is that this is an issue that wasn't subject to the motion. When they asked for particular relief, we've said that was where we thought we had an agreement on this. If there's an issue on something on our that we had something on our privilege log, which they asked for in their motion, is that we do that by Monday the 8th, which we said was fine. We'd do that, or Monday the 1st, by next Monday. And if we produce something on our privilege log and they want to challenge it, then Your Honor, at that time, per the rules, we will provide affidavits and documents proving up, the audits of what we're doing. But I candidly, Judge, I think that what I understand about this audit and what I understand the language being there, I'm just not, I think when they move forward, we'll deal with it. But right now, I'm not sure that I know enough to be able to respond, in the way that I think you're asking, because I understand your point.
But when did this issue involving the draft audit come up in terms of briefing?
Last night, Your Honor, because Mr. Irabali, for the first time ever, when they produced documents at 7 o'clock last night before my deposition this morning of their client, that's the first time there's the mention of this draft audit. I couldn't have, we knew there were documents that were being hidden. That's why I filed the motion, because I'm saying I know there's no way that we have everything. Then on Friday, when Mr. Irabali finally told the auditors that they could release their documents to us, that's when we started going through the thousands of pages that the auditors produced on Friday. And when a lot of these issues came to light, and then like I said, Mr. Irabali last night for the first time produces the email that demonstrates not only is there a draft audit, but Southfield was reviewing the draft audit.
Yeah, Your Honor, the point is it's not right now. I get that they didn't get it yesterday. I understand she's complaining. We're more than happy to deal with that, but it's just not something that
it is right. It's responsive. Directly responsive to Your Honor's order from last month.
Your Honor, the point is there's no motion. They have filed a motion that asks for particular relief. We've agreed to that relief. They now want you to overrule privilege and things. That's not something they've moved on. There's a very specific procedure and we're allowed to put evidence on. They're trying to go past that.
This was directly responsive to your order a month ago.
I don't want to be very clear, Your Honor. We have never withheld anything that we don't feel like we have a solid basis for asserting privilege on. These are communications with the FSG defendants about the draft audit. These are not communications.
But the draft audit hasn't been produced. Is that correct?
Correct.
I just don't, I guess that's where, but I understand it just came up last night. I do agree with Mr. Harper that it's not ripe. It does appear to be in violation of my order that has not been produced. I'm not saying it is, I'm not making any rulings, but I do want to kind of indicate that I think this is a big concern and it needs to get dealt with right away. If that's the case, that there's a draft audit and it hasn't been produced. The other issues I'm not quite as concerned about, though I understand Ms. Pettit's concern. I would say let's go ahead and reset this to Monday. Is that what you guys had agreed to, Mr. Harper? Is that you were going to provide a privilege log by next Monday? Is that I guess you kind of said something I wasn't.
That's what's in our motion, Judge. I mean, again, I think we can have it done by Friday if we want to have it earlier. And that way, again, we're happy to try to work things out or determine where there are problems. Because again, we're not trying to. We're happy to deal with whatever issues are there, and I understand exactly what the court is saying, and we will take that message to heart. But so if we want to make it Friday to move things up a little faster,
why don't we do this? Why don't you get her the privilege log by Friday, and we'll have a hearing on this on next Monday, because I know we have a special setting coming up. Is there any more news from the Court of Appeals?
No, we produced our response letter, I can't remember, one day last week. So I anticipate we'll hear something soon based on that confusion they had on whether or not the issue was moved.
Okay. So next Monday is and I signed the order. Did you guys see that?
Yes, Your Honor, we did. And we provided it to them.
And so let's go ahead, get the privilege log in by Friday, and we'll have a hearing on all this stuff by Monday. Mr. Harper, Ms. Eash, or all defendants, I would highly recommend you seriously look at the issue of this draft audit. If there's any additional depositions that need to take place because of this late production, we'll have to discuss how to allocate cost on that once we get on more detail. Anything else we need to chat about? This went way over time. We only had 15 minutes scheduled for today.
Sorry, Judge.
Is that good, guys?
Thank you, Your Honor.
Yes, sure.
Thank you, guys. You have a good day, okay?
You too.
And get me an order.
Will do, Judge.
Yes, Your Honor.
Judge, you want to set for Monday at what time?
Oh, sorry. Let's do Monday at 3, Mr. Irabali. I think everyone will sign off.
Yes, Your Honor. I will let
next
everyone
Monday
know.
at 3.
Sticky on the door that lets somebody know that hearing's in progress. What's that?
It's a little sticky, but it's okay.
Mr. Slate, you need to mute. Mr. Slates, you're unmuted.
Sorry.
That's okay. Just so you know, you're not up yet. Kazonga versus Amaya, DC 192213. Matong is the plaintiff's attorney. Washburn is the defense attorney. Anyone here in that case?
Judge, I believe that's me, Camilo Valencia for the plaintiff, Kazonga.
Joseph Washburn for the defendant.
Okay. Tony, let's go on the record on DC 192213. Kazonga via Amaya. Counsel, make your appearances again. Sorry.
Camilo Valencia for the plaintiff, Judge.
Joseph Washburn for the defendant, Your Honor.
Okay. You can make your argument. I've read the briefing.
Judge, I wanted to announce to the court that we have an agreement on this matter.
Oh, good.
We've agreed on a settlement so we can avoid all potential appellate issues that may arise from it. And,
Okay.
We're in the process of finalizing that settlement, but there is a Rule 11.
Let me just look at something real quick.
Sure.
This case is closed, so there's nothing really we need to do at this point. So yeah, nothing that in immediate that we have to do at this point. So you guys have a great day. Okay.
Will do.
Thank you.
Good luck. Let's go to our 9:30 hearing. We're a bit behind. Adams v. Doe. That's a scheduling conference. Are both sides here on that?
Plaintiff's lawyer is here, Your Honor, Chris Carr with Lyons and Simmons.
Ty Bailey here, Your Honor.
Casey Campbell's here as well, Your Honor.
Jeff Wood, Your Honor, here on behalf of Dr. Odedra.
All right. What did we figure out, guys?
Judge, the proposal we discussed on Friday is agreeable to my client, the hospital, to go forward with the November 29th setting. I've talked with Mr. Campbell and Mr. Shell at their firm, and they will be substituting in as counsel for the hospital. We'll hopefully get something on file today there. But we can go forward with a special setting on the 29th with the court's proviso that if we're in red, 6 jurors. If it's orange, green, yellow, full 12.
That's agreeable to everybody?
Agreeable to plaintiffs, Your Honor.
Yes, Your Honor.
Yes, Your
All right,
Honor.
let's just put this on the record real quick. We're going on the record on DC 20-17490. Counsel, make your appearances.
Chris Carr with the firm of Lyons and Simmons on behalf of the plaintiffs.
Ty Bailey, the firm Thiebaud Remington Thornton Bailey here for Texas Health Presbyterian Hospital, Flower Mound.
Casey Campbell with Shell Cooley Campbell substituting in for the hospital.
Jeff Wood, Your Honor, the Steed Law Firm on behalf of Dr. Odedra and USACS Management.
Okay, we had an extensive discussion last week about this case. The defendants, Mr. Bailey, requested a continuance of this case, given the medical condition of his partner. The court urged the parties to reach an agreement on that. The parties have agreed, as I understand it, to reset this to November 29th, with one proviso that if the Dallas County COVID threat level is at red, that the parties will agree to a 6-person jury, and we'll have alternates. I don't think that would, just so everybody knows, we'll have alternates if that happens. But if it is not at red, if it's any lower level, then we would have a normal 12-person jury. Is that agreeable to everybody?
Your Honor, for the plaintiffs, it is. I would like the record to reflect that it's a special setting on November 20th.
And it is a special setting. You're absolutely correct.
Your Honor, agreeable to defendant Flower Mound Hospital.
As substituting counsel, we agree as well, Your Honor.
Your Honor, on behalf of Dr. Odedra, we agree as well.
Was there another attorney on this? I thought there was one more set of attorneys, or is this everybody?
Settled.
There's a defendant that's settled, Your Honor.
Okay. They're not here. Okay. All right, guys. Rhonda, go ahead and reset this to November 29th. Put in the notes that they've agreed to a 6-person jury if we're in red. Mr. Bailey, we wish you and your firm the very best of luck. I know you had a tough year, and I really am sorry to hear that. And court wanted to make sure we could do everything we could to try to accommodate that. So I'm really sorry about what you're going through. We wish you the best of luck.
Thank you, Judge. I appreciate that.
All right, you guys are excused. Have a great rest of your week, okay?
Your Honor, with your permission, can the plaintiffs take the first shot at reworking the scheduling order that the court put in place for the court's consideration?
Yes, go ahead and try to get that worked out. I'd urge defendants in the strongest of all possible terms to try to reach an agreement on this. We're moving this. You can't use the situation as a sword and a shield. So just make sure that you work together on this. Okay, guys.
Understood.
Thank you, Your Honor.
Thank you, guys. All right. I don't know that I think I've seen both of the attorneys on this. Are both sides here on Thong Sabat versus Bennett or Urban Lots Bennett LLC?
Plaintiff's here and ready, Your Honor. Mr. Slates was here a few minutes ago.
Yeah, his sound was...
I'm here. Sorry, I had to unmute. Sorry about that.
It's all right. Do y'all want a record on this? It's a summary judgment.
I don't think we need one, but
no, I don't think we need
Mr.
one.
Slates.
All right, let's proceed, guys.
I don't know if the court's had a chance to read the pleadings, but I think you're generally
I have.
familiar with this case. As you recall, we were close to a trial setting earlier this summer and believed we had everything resolved. And I think we do have everything resolved. We are in the process. As you know, we quit claim deeded the disputed property to the plaintiffs, which mooted the declaratory judgment claim and mooted the trespass to title claim. The only remaining issue out there was just relocating some pavers that are at the base of the fence to be in line with the fence. And we're in the process of doing that. There is one last outstanding issue that we're waiting for some feedback from the plaintiffs on as it relates to a piece of the property on the back of their property where it kind of is at an angle. And so once we get feedback from them on that, we will move those pavers consistent with the parties' agreement on the property line at that location. Leaving open, really the only open issue in my mind is whether or not the plaintiffs have any right to recover attorney's fees. And under the trespass to title claim does not provide for recovery of attorney's fees. The only way that the plaintiffs could get to an attorney's fees claim is if they had a valid declaratory judgment action, and we don't believe that they do. There was case law that came out that said you can't recover attorney's fees under declaratory judgment action. And then the legislature came back and said you can, but only if the determination of the boundary line is the sole issue in the case. If there's anything else going on, this needs to be a trespass claim and needs to be pled that way. And as we just discussed, this other issue that's involved here, besides the boundary line, are these pavers that are at the base of the fence. The plaintiffs claim that is a trespass. And so that injects something into this case other than just determination of the boundary line. And for that reason, even if we had not quit claim deeded the disputed property to the plaintiffs, we don't believe that the plaintiffs would be entitled to recover attorney's fees in this cause of action because it isn't solely about determining the boundary. The plaintiffs have raised issues with timeliness. We're set for a bench trial next Tuesday, Your Honor. I mean, we're really just deciding this in a more efficient and effective manner than we would do next Tuesday if we were to call this to a bench trial. It's kind of, it seems to me an objection that doesn't make a lot of sense given the practicalities of how the case is positioned. But even if that weren't the case, we have submitted case law to the court that says subject matter jurisdiction can be challenged at any time. And we believe that the issues in this case are moot. And so therefore the court no longer has subject matter jurisdiction and the case should be dismissed altogether.
Your Honor, this quitclaim deed that they're so proud of, they couldn't bring themselves to execute it unilaterally and file it for almost 3 years. During that 3 years, there were 3 separate events of trespass onto the property of the plaintiffs that created additional damages. They built improvements on the plaintiff's lot 12 without the consent of the plaintiffs. So all during those 3 relevant trespass issues, all of which predated this quitclaim deed, the relevancy of the title, the relevancy of where the boundary line was, the relevancy of the declarations of whether the 439 square feet of property they were claiming had been in the possession and on the south side of the fence of lot 12 since 1994. So we take great issue with the idea that a quitclaim deed that was only unilaterally prepared and filed in November of last year could make entirely moot things that have been going on about who owned the property that was being trespassed on and improvements placed on, all of which occurred before the quitclaim deed. So we don't, just chronologically, we don't know how the mootness argument gets any traction at all. However, they've not mentioned at all the fact that there is a 2011 Dallas Court of Appeals case written by Justice Fitzgerald. It's the Hansen case cited on page 14 of our response, page 10 of our response, that flat says, even if all of the arguments they make about mootness were true, which we don't believe they could be chronologically, still, as long as the plaintiffs are asserting a claim for attorney's fees under the Declaratory Judgments Act, that part of the case presents a live controversy and the issue of mootness is not present. So what we have here is mootness cannot be, as a matter of this Dallas decision, a grounds to grant a summary judgment on the balance of the case, or certainly on the attorney's fees. So we think the court should have the non-jury trial next Tuesday, and we'd prefer that it be.
Mr. Adams, what will be the issues left on that? It would be the attorney's fees and what else?
It'd be the attorney's fees and the mental anguish damages and other things on the 3 trespass issues. One of those is a little complicated. The court will remember we had sued because there was this fence was built inside, the retainer fence was built inside the boundary line, even with the new quitclaim deed. And we, at the encouragement of the court, the parties agreed that the defendant would remove that retaining fence and move it back to the line of demarcation that its quitclaim deed called for. And we agreed. The lawyers may have kind of overloaded the parties' abilities to do it, but the lawyers agreed that that would be done in a temporary settlement that we dictated to the court. It would be done, I think we agreed in 30 days. And as time went on, that got less and less possible. And so it's still not completely finished. Just so that issue won't interfere with the trial, John and I probably should agree on the record that that should be taken up technically as a separate issue to allow the defendant additional time to see if they can comply with that settlement, because we're not suffering that they're not completing it timely. And so once that issue is off the table, what we have is there are 3 separate events.
So, Mr. Adams, let's address that real quick. If we're going to try this case, and I'd like to try it next Tuesday, it doesn't sound to be super long. I don't want to try just part of the case. We need to try the entire case. So if that's an issue, either you need to tee it up for next Tuesday or we need to move the trial setting. I don't want to try part of the case, but not all of the case. Which is what I understood you to say.
Well, we've already settled the part that we're not going to present next Tuesday. So, and the court's approved it and we've got a Rule 11 on it. It's just that the performance has not taken place yet. So we don't need to try it. We just need to come up with some procedural.
But at this point, they're in violation of the Rule 11. Is that my understanding?
That technically they're in violation of the Rule 11 in terms of being able to complete it on the time agreed. Slates has stated that they need some more guidance from my clients about the performance that we've agreed to, and I think we all understood what it was. But if not, we can resolve that, certainly between now and next Tuesday. So it's not an issue that the court's going to leave dangling. It's been settled, is my point.
Well, I guess my concern is that let's say they don't do it. That would be an issue. I mean, right now they are in breach of contract, correct?
They're in breach of that partial settlement. Yes.
Yeah, the partial settlement. If we're going to, you've decided not, I guess, at this point to pursue that claim, but it's an outstanding claim. I guess that's my concern is if there's still an outstanding claim, either you need to pursue it or not. I don't really want to try the case and then have this other thing dangling out there.
Judge, the only procedural band-aid we might be able to use to fix it would be under Rule 174. We could say, we believe this issue has been settled. And if it fails to come to fruition, the performance is not there, the court could give that issue a separate trial, all under the same cause number. That would prevent it from being something that's completely dangling and unaddressed in the trial next week.
That's not a procedure. I mean, it doesn't seem to make
not a very popular thing, but it
doesn't make sense from a judicial economy. I guess that's my question, is just if we're going to do 2 separate trials on this, why do 2 separate trials? Why don't we just either tee it up for this trial or move this trial setting? The issue is that I think we could reach you next week. I'm not sure that when we could reach you again, because you're a non-jury. And there's no way to settle these remaining claims. They don't seem that serious.
Your Honor, can I respond to a couple of the issues raised by Mr. Adams?
Sure.
So He took the position, I believe, that there were 3 trespasses that were still at issue. The factual basis for those, as I understand it from their pleadings, is one of them is one of the workers put a note on his client's door that said, we need to move the fence. Obviously, that note didn't cause them any damage. The second is that they removed the fence, which obviously that is an issue, but we've replaced the fence, as you know, Your Honor, on the same fence line. The old fence was a chain link fence. This is a much nicer wooden fence. So I don't think there's any damage there. The third issue is the pavers, what Mr. Adams calls the retaining wall that's at the base of the fence. As I said, that's being moved. We're working together in good faith on that. And if I could just share my screen for a second, Your Honor, I had reached out. Let's see, is that the right one? There it is. Sorry. I had reached out to Mr. Adams earlier this month and said, hey, we'd like to move the fence a little bit so that it's in line with what everyone agrees is the property line. Also asking if we needed to go ahead on the attorney's fees issue. I didn't hear back from him. And so I reached out again. I'd really like to hear back on relocating the property line on the rear of the property where it angles towards your client's side. I got a response from him that said, sorry, this slipped through the cracks. I'll contact my clients immediately and get back to you ASAP. We haven't heard back yet, but as soon as we do, we're going to implement the rest of the work that's required to relocate the fence. And so to Mr. Adams' point, I don't think that that's something that there's any realistic possibility of remaining in dispute between the parties. And so really the only issue is the attorney's fees. And while Mr. Adams has addressed whether or not the mootness can resolve the attorney's fees issue, he didn't rebut in any way or reply in any way to our position that the only time that a declaratory judgment action is available to a plaintiff in a case like this is if the sole dispute is determination of the boundary line. And we know now from this whole argument that that's not the sole dispute, that there were other issues alleged. And so I don't see any possible way that they could have a right to recover attorney's fees given the undisputed facts and the fact that Mr. Adams himself has raised no reply or response whatsoever to the argument that you can't recover attorney's fees under the Declaratory Judgment Act unless the determination of the property line is the sole issue in dispute. So I think the case is proper for dismissal on summary judgment. And if in fact, I don't foresee any issue whatsoever coming up with the implementation of the relocation of the retaining wall pavers. But if it did, then certainly Mr. Adams could and his client could make a claim for breach of contract, but I just don't see that happening.
Okay, so as I see it, we have 2 options here. I'm going to deny the summary judgment. We could either go forward with the entire trial next week. I don't want to do separate trials, or we can move this trial setting. There isn't a great date to reset it to. That's part of the problem. So I'd kind of like to go forward next Tuesday. But what is your preference, Mr. Adams?
Judge, I'd prefer to go forth. My clients have instructed me that this case is way too old, and they're put out with me just because of the age, and who could blame them? So they want us to go forth next Tuesday. I would like to question, for a number of reasons. I think my clients would be more comfortable presenting this live as opposed to
that. Unfortunately, is not a possibility. So if you want to go forward next Tuesday, that is not a possibility. So if you want to go forward next Tuesday, it will have to be remote.
Okay. Well, my expert needs to know and my clients need to know, but our preference is to try it non-jury to you next Tuesday and see if we can't get it all done in one day. The other alternative to this dangling issue that lawyer Slates and I have about the moving the temporary fence or moving the retainer fence, I suppose we could by agreement submit that to the court in the form of an agreed specific performance relief, that this is the settlement agreement and we're waiving the 30-day time frame. And in that regard, the parties could stipulate that this is going to be done by agreement.
I
under
mean,
the
I
specific
agree with you. I
format.
think this could be done as an agreed judgment or partial judgment.
Yeah.
If you want to detail that, and then it could be enforced through a show cause as opposed to through a breach of contract. If it's part
That'd
of
be
the
better than
judgment.
dividing the issues up, and I understand the court wouldn't want to do that, nor would my clients probably want me to tolerate that as an outcome. So,
Mr. Slates, how do you feel about that?
I mean, if the court's denying the motion for summary judgment, then I guess we need to go forward next week. You know, obviously, I don't believe this is necessary, but you've made it clear that's the direction you're headed. So I guess we need to move forward.
I meant on the issue of the agreed judgment to deal with the paver issue.
Yeah. No, I don't have a problem handling it that way. As I said, I don't anticipate there being any issue with us finishing up the implementation of this as soon as we get some feedback from Mr. Adams' clients.
I will say this. I really think this is something you guys should be able to work out. If we can avoid a trial, I would try to avoid a trial. We're going to have one day to try this, so you guys need to kind of figure that out. If we can't, I'll probably put you. I mean, we're going to have to put you on some type of time limits, but I just don't see how much is left here, especially if you guys do the agreed judgment. So try to work this out. Do you guys want me to put you into a breakout room right now to see if you can work all these details out, or do you guys want to just call each other? Or
we'll get in touch. I need to visit with my people, and they'll be available later today if John's available.
Yeah, I can talk later today. I guess, Mr. Adams, I would just ask that you give some thought to and discuss with your clients what even is that we're going to be trying next week, because I'm really unclear as to what evidence, if any, we would need to put on at this point.
Well, we still have the trespass, tort, personal injury claims. They may not be at this stage, now that the title dispute is out of the case. Those may not be the kind we can recover attorney's fees on. So we might have to segregate the things we're fighting about that are not related to the declaratory judgment. But with that in mind, you know, I'll go back and read the cases on segregation and try to make sure I comply with it.
All right, let's talk later today.
Okay.
Let's, Mr. Adams, I urge you to really try to work this out if you can. It doesn't seem like there's a lot left, but if not, we'll see you on Tuesday. Let us know if you guys are able to reach a full settlement.
Okay, Judge. Thank you.
Thank you.
I've submitted an order that simply denies the summary judgment, which I think would be sufficient.
Let me
now
just
that we
see if
have
I
this
have
other
it.
stuff.
Yep, I have it.
Your Honor, this is Gerald Sager, if I may. I'm also an attorney for the defendant, Urban Lofts.
Okay.
And just want some clarity. It's part of the motion that's for the hearing today is about the title dispute, the trespass to try title, and the boundary line, which appear to be moot because of the deed from defendant to plaintiffs. And just want some confirmation that title dispute is no longer at issue. And if this case goes to trial, whether next week or some other time, that the title will not be part of.
Yeah, I don't see the title being part of this. It would be the issue of attorney's fees and the trespass would be what we'd be trying next week.
I think that's right. The titles, it's certainly not disputed any longer. There was 3 years where it was disputed, and that led to other damages, but the title itself has been taken off the table with the quit claim deed.
Okay. Thank you.
Tuesday at 9 o'clock and by Zoom hearing.
By Zoom hearing, the same link.
Okay. Thank you, Judge.
Thank you, guys. You have a good day.
Thank you, Judge.
All right, our next hearing is Ashley versus Progressive Transportation, DC 217667.
Morning,
here in that case.
Omar Chaudhry for plaintiff friendly Ashley.
Lisa Yerger for defendants.
All right, we're here on a continuance motion. Kind of give me the lay of the land.
Yeah, yes, Your Honor. We filed a joint agreed continuance on this matter. Discovery is substantially complete. I know defendants were seeking some additional medical records, which have been requested, but I don't know if they've been provided to defendants yet as far as from their subpoena. We are through with depositions, may have a medical expert that needs to be taken if we cannot successfully mediate this case, but we are mediating in September with King Pfeiffer, September 21st, and that's all scheduled. So we believe now we're completely ready for mediation.
So the main issue I just had, I don't have any problem with continuing it, is you guys requested a special setting, and I didn't see any basis for that. And so that's why I wanted to chat with you guys.
Yeah, and the only reason, Your Honor, we requested a special setting was that this case is ripe for trial. There's going to be nothing more needed after mediation, and we just wanted to make sure, just in the interest of justice, rather than, I know the dockets are getting backed up there, but that was just a request that we wanted to make with the judge or with the court.
Yeah. Just so you know, generally, because this would have been easily signed if it hadn't been for that request, is that we don't generally provide special settings in situations like that. It would be in situations where there's extreme complexity, where you have a lot of experts you have to line up, or you have parties who are from out of state that need to travel, and we have to kind of arrange for that, although that's becoming less necessary with a lot of witnesses testifying via Zoom. But just because you want to try a case, once your mediation is over, doesn't mean you get a special setting, because that allows you to cut in front of all the older cases.
Yes, Your Honor.
Does that make sense?
Yeah, it does. We would ask.
You just want a continuance at this point.
Yeah, that's fine.
Okay. When do y'all want to be reset to?
Ideally, October 2022 would be. We didn't need a long continuance. October 2022 would be ideal.
On cases of this age, it's a pretty, relatively new case. It's a 21. We're not setting many of those until next year, just because of the backlog, but just to give you a better chance of actually going. But if you want to be set earlier, we could set you earlier.
Yeah, that would be helpful, Your Honor.
What is the opposing counsel's view on this?
I also have a MSJ pending that I need to set for hearing. It was timely filed, but we weren't able to get it set for hearing because we are set for trial tomorrow. Okay. So as long as we're reset more than 60 days, I'm good.
Okay. So I guess the question is, do you want to be set in October with the understanding there's a good chance you won't get reached, or would you rather be reset next year?
I mean, I know plaintiff prefers sooner rather than later. I would rather have next year where we actually have a chance of going. I don't see the point in getting ready for trial if we're not going to get reached.
Rhonda, do you see any? I doubt there's any days in October where they would be number one. Let me see.
Looking at it.
Because it's such a new case.
Now for 2021, that's going to be hard.
Yeah, there's not any cases in 2021. I mean, you're going to be well down the docket. If you guys could reach an agreement, let's see, maybe January 17th. Yeah, you're still pretty far down the docket then too. How about Valentine's Day?
That's fine by me, Your Honor.
Yeah, you're still not number one, but you're closer. So let's go ahead and set it to February 14th. Don't mean to ruin anyone's Valentine's Day, but you guys will settle, and We'll get this order in today. Rhonda, go ahead and reset it to February 14th, 2023. And it will not be specially set.
Thank you, Your Honor.
Thank
All
you,
right,
Judge.
guys, you have a great rest of your day.
You too.
Thank you.
Okay. Our next case is, we have a busy docket this morning. Trinity Industries Leasing versus Lattimore. Actually, let me deal with the scheduling conferences first. Anyone here on Anderson versus O'Neill?
Yes, Your Honor. Chris Laster here for Kevin Anderson.
Rob Castle here for defendant, Your Honor.
When do you guys want to be set for trial?
Your Honor, earlier this morning, we submitted an agreed scheduling order setting the case for trial, I believe, for the week of February 20th of 2023. I don't know if it's made it into your queue yet. It was accepted.
Yeah, that was, it got in pretty quick. That's unusual. It's that quick. The trial setting would be February 20th. Is that the idea?
Yes, Your Honor.
Yes, Your Honor.
Is that a Tuesday? I think that's a Monday, isn't it?
It is a Monday, Your Honor. But
yeah, so we'll reset that. I'll just interline it and we'll put it on the Tuesday.
Tuesday the 1st?
The 21st, yeah.
Very good.
All right. Anything else y'all need to chat about?
Not from the plaintiff's side.
Not from the defendant, Your Honor.
Okay. Well, you guys have a great rest of your day, and we'll see you on the next one.
Thank you so much.
All right. We have one more. There we go. We have one more scheduling conference set for today. All right, Carino versus Gomes, DC 2115716. Rafi is the plaintiff's attorney, Martinez is the defense attorney. Anyone here in that case?
Yes, good morning, Your Honor. Fernando Martinez here for the defendant.
Anyone here for the plaintiff? Anyone here for the plaintiff? Have you all worked something out?
Your Honor, I've been trying to get a hold of plaintiff counsel and have been unable to do so on an unrelated case as well as on this matter for multiple attempts.
Okay.
We did have on this case, I think the last I saw plaintiff counsel was back on June 16th. We didn't discuss scheduling at that point. It was a deposition of a non-party. But that's about where we are, Your Honor, since I've been trying to get a hold of them.
Okay, well, that's strange. Is that Aisha Rafi or Kyle DeBose, or who's the attorney on that?
I think technically on this one, it's Aisha. Kyle has appeared at that deposition back in June. And I've emailed them both. I've tried calling and leaving voicemails, I think as recently as Friday, specifically for this case on Friday. And I'm just kind of here on the ship without a steering wheel, Your Honor.
Okay. Well, the advantage you have now is you get to pick the trial setting within reason. So when do you want to set this for trial?
Oh. You said 2023 is what we're looking at, Your Honor?
Oh, yeah.
I'm fine with just about anything, to be honest. And we don't have a deadline. At some point, I'd like to file an MSJ on this case. So, I mean,
how does
April?
How does
April's fine as long as you're not ruining my Valentine's Day. I think we're golden.
How does April 18th sound?
That sounds just fine, Your Honor.
Rhonda, are you there? Can you go ahead and reset this case to April 18th?
Yes, Judge.
Okay.
Now, Your Honor, it was filed as a level 3, but absent an actual order. We've just kind of been following level 2 discovery deadlines. Would that be fine up until potentially an agreed order is submitted?
I don't care at all. So whatever you guys want to do is fine with me. The main purpose of these scheduling conferences is just to get a trial setting in place. It's something that I kind of learned from a previous judge when and this is how I've always approached it. If you have a level 3, we're not allowed to just pick the trial setting without chatting with you guys first. And so that's why we set these for scheduling conference. And so if you guys want to move it to a level 2, just follow appropriate motions. I'm not going to do it sua sponte because the other side's not here. But yeah, you can put together whatever kind of scheduling order you want with that trial setting and submit it, and obviously share it with the other side, and hopefully they'll get back to you.
Your Honor, that sounds great.
All right. Have a great rest of your day. Okay.
Thank you, Your Honor. Been too long. Good seeing you again.
Good to see you as well. Good to see you as well. I hope you have a good week. Okay.
We appreciate your time. Thank you, Your Honor.
Thank you. Give me 1 second. All right. I think our next one, do we have anyone else on the scheduling conference docket that I haven't spoken to yet?
Yes. My DC is 22-02242.
Okay. Oh, I think I know what that's about. You guys are, yeah, you're set after the motion to compel. So we'll take care of the motion to compel, then we'll get to you. Okay.
Oh, okay. Thank you.
All right. Are both sides here in Trinity Industries versus Lattimore?
Yes, Your Honor. Good morning. Charlie Jones for the plaintiff, Trinity Industries Leasing Company. I'm joined by my colleague, Ms. Giamatorio.
Okay.
Good morning, Your Honor. Aaron Michelson for Lattimore Materials Corp., the movement this morning in the motion to compel. Your Honor, as requested at the hearing in this matter on Friday, my office provided a checklist, a proposed order.
Oh, great.
I believe that was filed with the court, but it was provided via email to Ms. Pinson.
Let me, when did you submit it?
I believe it was Friday afternoon, Your Honor.
Okay, for some reason that hasn't, well, let me see, maybe it's here. No, it hasn't come through. Rhonda, can you email that to me so I have it?
I'm looking for it now, Judge, but I don't see it in my email. You said it was emailed this morning, sir?
No, Friday.
Friday.
Who would it be from? So she can have an easier time finding it.
I believe from my paralegal, Miss Lisa Padilla. It was Friday, Your Honor. It was a little later in the afternoon. It was at 5:58 p.m. on Friday.
Okay, that'll help a lot. Do you see it, Rhonda?
Yes, I do.
Can you forward that to me?
Yes. You should have it right about now.
All right, let's go ahead and get started on this. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 208632, Trinity Industries Leasing Company versus Lattimore Materials Corporation. Counsel, make your appearances.
Good morning, Your Honor. Charlie Jones with Haynes and Boone on behalf of the plaintiff, Trinity Industries Leasing Company. I'm joined by Ms. Carrington Giamatorio of my firm. Thank you.
Thank you.
Good morning, Your Honor. Aaron Michelson for the movement, Lattimore Materials Corp. And if I may, Your Honor, I've put together a short PowerPoint presentation for the court, if it may please the court.
Okay, give me 1 second. I'm just printing out this order so that I can have the checklist.
When did that come in?
Oh, dear. All right. I'm not sure I'm going to have time to hear all this, but okay, let's do our best. All right, go ahead and share.
Your Honor, I've shared my screen with the court. And if I may just take a moment to provide some brief background information that may obviate some questions later in this morning's hearing. This is a matter between the movement Lattimore and Trinity pertaining specifically to maintenance of what are called RDLA open top hopper rail cars. Lattimore leased these from Trinity, and the maintenance was performed almost exclusively by what are called mobile repair units. Other similarly situated Trinity customers who leased rail cars and hauled the same types of materials using.
Your sound is cutting out. You may need to speak more closely to the microphone.
I apologize, Your Honor. Is this a little better?
That's better.
These other Trinity customers also experienced corrosion issues in the same rail cars. Now, in December of 2018, Lattimore signed some lease renewals with Trinity. And in January of 2019, Trinity actually told Lattimore that the rail cars needed to be rebodied. So Lattimore has brought some fraud claims and various affirmative defenses, including mitigation, failure to mitigate. And Lattimore is entitled to know what Trinity knew about its systemic corrosion issues and when Trinity knew it. And to explore that, Lattimore has conducted some rather extensive discovery, and some issues with responses have come up during the discovery period, and these issues were raised with Trinity during the discovery period. There are a couple of different areas. First, Trinity just failed to collect discovery from two custodians that Trinity itself identified as having relevant knowledge. Now, an oversight. These are screenshots from Exhibit 1 to the motion. These are
Judge, let me just jump right in here. We've told Mr. Michelson that we've collected from these guys. We have the production on these two individuals ready to go, and we agreed to produce the documents to them. We reached out to them and never heard back from them on it. So I'm ready to produce documents from Mr. Fletcher and Mr. Walton.
Great, Your Honor. Then we won't have to deal with those. The next, there are a number of individuals that came out towards the end of discovery that Trinity hadn't named as potentially possessing relevant knowledge. Trinity also didn't collect from these individuals. Jeff Younger, who was on a maintenance inspection team here from Exhibit 3, shows that he received inspection information with regard to these rail cars in question. Miss Cynthia Conder, who was a director of contract administration, she was involved in creating the lease renewal riders, drafting them that were executed by Lattimore. This is testimony from Mike Fry, who was a Trinity sales employee, and that's at Exhibit 4. Mr. Bimmerly, Stan Bimmerly, he's a controller. He specifically had discussions with regard to third-party maintenance entities who provided maintenance on the rail cars in question. Mr. J. Tulamieri, he was he's on Trinity's sales team. He was the Trinity sales representative servicing Lattimore's rail cars during pertinent times in this lawsuit, early to mid 2010s. Jeff Torbert, also on Trinity's sales team, responsible for servicing another similarly situated entity leasing from Trinity who was using their rail cars in almost the exact same way as Lattimore. And that entity is Vulcan, as shown here in this testimony from Exhibit 4. Also, a man named Scott Driggers, the Vice President of Fleet Maintenance, responsible for choosing these third-party maintenance providers. And two folks who oversaw one of Trinity's maintenance facilities in Hugo, Oklahoma, that did maintenance on Trinity's RDLA hopper fleet. Mr. Wright passed away, and Mr. Sainer took over for him, from what we understand. So these are individuals that towards the end of discovery, it came out that they had relevant knowledge with regard to information on the lawsuits, and no discovery was collected from them.
May I respond on the custodian issue, Your Honor?
Yeah.
Ms. Giammatori, if you could pull up this is just a giant red herring, Your Honor. It's designed to disrail this trial. If you could please go to slide 3 of our presentation. The truth, Your Honor, is that Lattimore has been derelict in prosecuting its case. That's what's going on here. And the law cited in our briefing is clear, Your Honor, that it's not your job to rescue them from failing to prosecute this case. On May 13th of this year, 10 days before the close of discovery, we got this list of custodians that Lattimore was demanding that we search and produce documents from. The date that each one of these custodians was disclosed in our document production is listed here. If Lattimore had just bothered to look at our documents, they could have seen all of these people. We didn't list them all on our RFD responses initially because we didn't believe that each one of these people had relevant knowledge. That said, we had a meet and confer before discovery closed. Lattimore identified these 5 people highlighted: Ms. Conder, Ms. Fletcher, Mr. Hurst, Mr. Tulamary, and Mr. Walton as the ones that they really needed to prosecute their case. So we went and collected that information, Your Honor. That was 321 gigabytes of data based on the search terms that the parties have at play. We reviewed the documents. Most of them were duplicative, but we have nonetheless agreed to produce data for these 5 people. But if you go back to slide 3, Your Honor, or Ms. Giammatori, we exchanged custodian lists in December of 2021. And Lattimore waited, despite having documents with all of these people's names on it, they waited until May 13th to raise the issue, just 10 days before the close of discovery. We asked them what they really need. We're going to give them those 5 that they say they really need, but we produced documents and collected from 26 separate custodians. Trinity is a large organization. They could make an argument that I should have to go ask 500 different people. We have kept this to reasonable bounds given what is at stake in this case. And what they've done is wait until the last minute to try and throw up a bunch of roadblocks to derail this case. If you go look, please, at 5 and 6, they say they learned all of this information during the deposition of Mr. Fry, Judge. And if where's the slide on Mr. Fry?
Your Honor, if I may finish my presentation.
Yeah. Look, I think you're just kind of hijacking his presentation at this point.
I'm just trying to get to the document custodians that they say they really need.
So yeah, we don't have a ton of time here. So what exactly are we? Your checklist order is extremely long and has a number of privilege log entries, and I don't know that I can hear all this today. I do have an idea. Are you going to want me to go through each of these different privilege log entries and take a look at documents? Is that the goal here?
Your Honor, that's the request. There are 86 separate entries. A good number of them are specifically photographs that are attached to emails. But if we'd like to discuss specifically the privilege log documents, each of the privilege log document entries that we've identified are not communications with attorneys. Now, the bare assertion that these are privileged just isn't good enough, Your Honor. First, some of these are actually external documents with non-Trinity entities, so that just could not be privileged. Some are communicate like privilege laws.
So let me ask this: are these actual? What I would usually do, I've never had 86 before, but what I would usually do in a situation like this is I would review if these are documents that I need to look at for assertions of privilege. I would go through each of the 86 while you guys are there and just ask you questions like, hey, who is this person? What is this about? So that we can resolve these issues. I've tried to do privilege logs on my own, and sometimes I can do it, but it is much more expeditious. Unfortunately, I don't really have time to go through 86, but we have an associate judge now who does have time tomorrow afternoon. If you really want all 86 of these documents or document requests to be reviewed, she may have time to do that tomorrow afternoon. Is that kind of what are you asking me to do here today? Is it to go through all 86 of these?
Well, Your Honor, I think ultimately that would be the procedure, an in-camera review. Obviously, I don't think Trinity is going to agree that the privilege log documents aren't privileged, and we've got no way of confirming that they are privileged. Just like the hearing on Friday, there needs to be some confirmation with regard to the hard drive. I believe there does with regard to these communications as well.
Judge, I think we could cut some of this short. One, Lattimore didn't bother to meet and confer on this issue. And if they had, I would have told them that 44 of the documents listed on this privilege log were produced in exact duplicate elsewhere in our production. They were marked as privileged because they were gathered by counsel to be reviewed as part of their background on this case. And so that was work product, their thinking that went in. But 44 of these documents have been produced in exact duplicate. Mr. Michelson would know that if he had conferred on this prior to filing the motion. The other half of the documents, we're happy to let the court take a look at. We're happy to let the court take a look at.
I apologize for speaking over Mr. Jones, Your Honor. There was a meet and confer. There was communications between counsel months ago at the end of 2021 with regard to the privilege log documents. I understand that counsel would have wanted further meet and confers, but we attempted to confer, Your Honor. I think if after the hearing we could get a list of the documents that Mr. Jones has just identified, I think that would be that he would have no problem with an in-camera review of. Then I think we can potentially bring it before the court or the associate judge and have that issue.
So let me ask this, just from a logistics standpoint. I think this is probably more appropriately brought to the associate judge. Do you have, would you be, from a logistical standpoint, would it be better to do that this Tuesday? Like, so tomorrow you guys could show up to her office, she could go through all of these different documents, or would be ready to wait a week so you have a chance to maybe confer more, or what would work better for y'all? But she's available for our court on Tuesday afternoon. So let me just jump. Rhonda, is she available next Tuesday afternoon too, just in case?
Yes, she is, Judge, at 1:30.
Your Honor, I think that would be smart. Tuesday the 2nd to give counsel an opportunity to confer.
Yes, agreed, Your Honor. And I'm happy to, I mean, we may go, I can't agree without asking my client, but we may go so far as to give Mr. Michelson the non-duplicative documents as long as there's not a subject matter waiver of privilege. I just need to ask my client on that. But this is really something you can't confer in December and then file a motion the following June and say you conferred on it, especially when we served intervening privilege logs, Judge.
And Your Honor, if I may, there's the custodians issue, and there are 3 depositions that are the subject of the motion that we had previously requested during the discovery period of counsel. And
Yeah, so there's three individuals. I'll rule on the issue of the depositions. There's Chris Afuli, it's CRISAFULLI, Mark Conley, and Jay Tulimeri, TULIMIERI. So what is the issue with those folks' deposition?
well, Your Honor, first, I'll just take them in alphabetical order. Mr. Conley, while he was, here is the actual identification of Mr. Conley from disclosures. He was disclosed relatively generally, and that's fine. However, Your Honor, it came out towards the end of discovery that Mr. Conley also was a sales team member with regard to another similarly situated Trinity lessee and Capital Aggregates. And until that time, we had not known that. It had not come out, and we'd like to have deposition testimony from Mr. Conley with regard to that, because it bears directly on mitigation of damages.
Okay, that makes sense. Response, Conley?
Your Honor, this is just a continuance in disguise. Mr. Conley was disclosed early on in this case, as is right here. You just heard Mr. Michelson say there's nothing wrong with his disclosure. In fact, under the rules, our disclosure is much more fulsome than was required. We can't name everything that Mr. Conley may have been a part of. Mr. Conley's name appeared on at least 3 exhibits that that Lattimore used.
Did you disclose Mr. Conley as a person with knowledge of relevant facts?
Yes, we did.
Okay.
In 2021. And
So
they waited until the end of discovery to seek his deposition.
So why did you guys wait to take his deposition?
Your Honor, the deposition testimony of Mike Fry is what begat this information with regard to Mr. Conley's relationship specifically with Capital Aggregates. And that has become a major issue in this matter. And Mr. Conley, it was, as we see here, never disclosed that he had anything to do with Capital Aggregates, only with regard to Lattimore's obligations, Lattimore's use, etc. And during discovery, we explored that, Lattimore explored that, and came to understand that Mr. Conley had further information, and we asked for a deposition during the discovery period of Mr. Conley.
Mr. Fry was originally set for deposition on December 16th. They didn't want it then. He was originally set, then he was reset for deposition on April 15th, and they didn't want it then. And then they waited till May 6th to take Mr. Fry's deposition. Also, there's no reason they couldn't have asked Trinity what Mr. Conley knew in detail through multiple other Trinity witnesses that were produced for deposition early in this case. An interrogatory about Capital Aggregates. We didn't disclose Mr. Conley as having knowledge of Capital Aggregates because we don't think any of that is relevant to this case, Your Honor. The fact is they knew about him and they could have taken a deposition. In the Woods case that we cite in our briefing, you don't just get to lay behind the log and then decide you want a bunch of depositions after discovery closes. And that's
right, so
what
I've heard the argument on Conley. Let's hear about Chris Foley.
Your Honor, Mr. Chris Foley is the Vice President of Engineering. It came out again in Mr. Fry's deposition that he is considered a subject matter expert, specifically with regard to open-top hopper cars, which is what is at issue here. He was not previously identified by Trinity, and when we came to understand from Mr. Fry that Mr. Crisafulli had potentially relevant knowledge, we asked for his deposition, plain and simple. I understand the idea that Trinity is saying that Lattimore waited too long, Your Honor. That just doesn't, I don't think, take into account the realities of discovery. That is, more information comes out in discovery, and during the discovery period, we requested further investigation of that information. And that's the long and the short of it.
Response?
Your Honor, we've given them all kinds of people on open top hopper cars. Open top hopper cars are one of our many products. There are probably dozens and dozens of people who know about open top hopper cars. We specifically interviewed Mr. Crisafulli, said he didn't have any knowledge of this case. We disclosed him in documentation as early as June of 2021. These are from meeting. This is the only real involvement he had, was a meeting in 2009. We've interviewed Mr. Crisafulli as part of our obligation in this case. Said he didn't have any recollection of this, but this is a meeting that Lattimore was in. They knew about Mr. Crisafulli. They used documents with Mr. Crisafulli's name on them in depositions as early as November 9, 2021.
Let me just ask this, but he was not disclosed in responses to requests for disclosure, correct?
No, Your Honor, because when we interviewed him, he said he didn't have any knowledge relevant to Lattimore. If he doesn't have any knowledge of the specific cars at issue in this case, if they just want to ask general questions about open top hopper cars in discovery in this case, depositions would never end, because there are literally dozens and dozens of people who work on and know about these hopper cars. He has no knowledge relevant to Lattimore, and they haven't established that he does.
We're not asking for dozens and dozens of depositions, Your Honor. As Mr. Jones said, Trinity even had an interview with Mr. Crisafulli because Trinity believed that Mr. Crisafulli had potentially relevant knowledge. Now that Trinity somehow the gatekeeper of who Lattimore can depose, I don't think that's a good precedent, Your Honor. I just don't. I think Mr. Crisafulli was not disclosed, and he has relevant knowledge, as Mr. Fry testified.
He's listed on the documents from June of 21 in a meeting that he had with Lattimore. Does Lattimore have no responsibility to investigate its own case and determine people? We don't think he has knowledge of relevant facts, Your Honor. He wasn't on our disclosures. He was in all sorts of documents produced to these guys as early as June of 2021.
And when testimony from Mr. Fry showed that Mr. Crisafulli does potentially have relevant knowledge.
So I guess I need a little more detail on what this means exactly. So Mr. Crisafulli knows about open top railroad cars. Does he know about, I don't know what that means exactly. I mean, we all know what an open top railroad car, does he design them? Does he deal with corrosion? Like what is his role exactly?
Well, that's one thing we'd like to know, Your Honor. Mr. Crisafulli has testified he is vice president of engineering. We have failure to mitigate affirmative defenses. We'd like to know what Trinity engineers did in the manufacture of the RDLA.
Is there any evidence that because you've gotten a lot of documents, is that Mr. Crisafulli is involved at all with corrosion or with this particular with Lattimore or anything like that? Or is there just that he knows about open top railroad cars?
Well, he knows about Trinity's open top RDLA hopper car fleet, and that is, Your Honor, with regard to other entities as well: Vulcan, Martin Marietta, Capital Aggregates. And so the exploration of what Trinity was doing with regard to corrosion in its RDLA hopper car fleet.
So there's evidence that he knows about the corrosion issue?
None. There's none, Your Honor. I would ask Mr. Michelson to point to that. The only thing he has is the testimony from Mr. Fry that Mr. Crisafulli is our vice president of engineering.
And Your Honor, that he's a subject matter expert with regard to these issues.
No.
Completely.
What he said.
Whoa,
Your Honor, I cannot point to specific evidence where Mr. Crisafulli is talking about corrosion, but corrosion.
Or is he on any meetings about corrosion or Lattimore or anything? Is there any other than that? Just one?
Nothing that we've seen, Your Honor.
That's all they
All
have.
right. All right. Okay. Let's deal with the last one, which is Tulamari.
Your Honor, Mr. Tulamari is relatively straightforward. He was not previously identified. He was Trinity's sales representative to Lattimore in the early to mid 2010s, specifically when the first lease extension was negotiated, Your Honor, and thereafter.
Your Honor, I think it's reasonable to produce Mr. Tulamari for deposition.
Okay.
But the other two are just, one, they didn't ask, and two, they have no proof that Mr. Crisafulli, despite our incredibly fulsome production, knows anything about the issues of this case.
All right. All right. So I'm going to go ahead and deny the request for Crisafulli and Conley. I will grant it for Tulamari. For everything else, Rhonda, go ahead and set this issue on Judge Tahira Merritt's hearing docket. Does she start at 1:30 or 1? Do you know?
1:30.
1:30. Okay. So you guys will be set with her on August 2nd at 1:30. And I urge you strongly to try to confer on all of these different document issues and go ahead and set that for how many hours do you think this is going to take to go over all this stuff? I don't know how extensive this is.
Frankly, Your Honor, I would say 2 hours right now. However, with regard to the privilege log documents, if we confer, I think we could probably get a lot less than that.
Go ahead and set it for 2 hours for Ms. Judge Merritt. I haven't been able to reach her. She may be in the middle of a hearing. And so if there's an issue with her schedule, then let me know and we'll let the parties know if they want to move it a week back or whatever. That's okay with me too.
Yes, sir.
Thank you guys. Any other questions? And I'll do an order on just the issues I've decided.
May we be excused, Your Honor?
Yes,
You may
sir.
have a good day.
Thank you, Your Honor.
One quick question, Your Honor. Just with regard to a notice of hearing in Judge Merritt's court, is that something I can take a look at her?
Yeah, go ahead and notice it. She, I think I'm going to talk to her about it, and she's a pretty new judge. I don't know how she's going to want to do it. I'm going to urge her to do it in person because she's going to have to be going through so many documents. She may have a procedure for how she does that. It's totally up to her if she wants to do it in person or remotely. And that'll be, something that she'll have to let you know if she wants to do it in person or remotely. But I'm going to kind of give her my thoughts that if I had time to do this, I would hear it in person just to go through all the documents. And she may also have a procedure on how far in advance she wants to get the documents. Have those documents already been produced in camera?
No, Your Honor, but they are sequestered for the purpose.
Okay. So yeah, go ahead and, but hopefully you guys, it'd be nice if you guys could work out as much as you can, and then you don't have to, just give her the documents you need to have rulings on.
Yes, Your Honor.
Understood.
All right, guys, good luck.
Thank you, Judge. Appreciate it. Have a good day.
You too. Okay, our next one is an exciting hearing. I think it says in the interest of AMT is the next case.
That's my case.
Okay. Let me just pull this up. All righty. So I took a look at everything. I'm a big believer that this is an important thing to do, and I understand fully why you want to have this done. And so I looked at all your documents. You submitted them correctly, and so I don't have any issues with it. We want you to be able to kind of get this taken care of as quickly as you can. Let me just tell you one thing that has come up in the past, and that is, is your goal to go to the DPS to get a new driver's license? Is that kind of the goal, one of the things you want to do?
My appointment is already set on the 29th of this month in 4 days.
Okay, good. So I'll go ahead and get the order signed today. You should be able to get it online. You should be able to get it online later today, hopefully. We have had issues in the distant past. This has not been a recent thing, but in the distant past where folks have gone to DPS and there'll be some manager there that gives them a hard time. You know, if that happens, that it's kind of rare. It hasn't happened in a while. If that does happen, please come back to us and we're glad to help you navigate that if you need to. I don't think you will, but if you need to. And otherwise, the court will go ahead and grant your order to change your name and your identity marker. So anything else you wanted to chat about?
No, Your Honor.
All right. Well, congratulations and have a great rest of your week. And I hope everything works out with DPS.
Thank you so much. Have a great day.
Thank you. All right. Mr. Cooks, give me a second. I need to take a quick break. We have an issue with my printer, so I'll be right back. Okay, sorry about that. We're having some printing issues. I think our next hearing is one of these annuity transfers. Is that correct?
Yes, Judge, I have it listed as being on the DWAP hearing, excuse me, on your DWAP docket. But if you're willing to go forward with it today, or definitely prepared to do that, I believe the annuitant is on the line. I'm not certain if my client has sent you the documents that you require, but if they have, then like I said, we're ready to go.
Let me see. I don't see it.
That's what I was concerned about. Okay. So Judge, I can get with Miss Rhonda and we can set the first available hearing.
Okay. I don't see, was this, you said this was on the DWAP docket today?
That's what I have it listed as.
Rhonda, go ahead and reset this on the DWAP docket for 30 days. This is NRA JG Wentworth Originations.
Got it.
All right, just go ahead and get that reset, and we wish you the best of luck. And we'll see you at the next hearing. Okay.
Yes, sir. Thank you. Judge, if you don't mind, Mr. Patel, that applies to you also, sir.
Mr. Patel, you'll need to provide the information required by the court. And Mr. Cooks, have you told them how to find that?
Judge, I'll call them as soon as this hearing is over.
Okay. All right. Good luck, guys.
All right, thank you, Judge.
Okay. All right, Rhonda, our next hearing's not until 3:30. At least that's what from what I checked this yesterday.
They cancel. Okay.
We had a ton of cancellations. We have a bunch between like 3:30 and yeah, we have 4 hearings between 3:30 and 4, but nothing else. So
Move up a little bit, or
what'd you say?
you want me to call them and see if they can move?
No, that's fine. 3:30. I have some stuff I want to go with the interns. So, all right. So Rhonda, Tony, I'll see you at 3:30.
Okay, 3:30 it is. Bye, y'all.
Thank you.
Bye-bye.
Okay, so let's chat real quick.